That's all I have to do the
And
whole
see,
time.
right, yeah, right now. Click it, they can hear you now.
Mhm.
Takes it off. And now you're unmuted so they can hear you. And then
Oh. No. Okay. Where is it, Rhoda?
That's okay.
unmuted.
Good morning.
Morning.
Hello.
No, but where's the motion that comes up?
Find your in here. Yeah.
All right, ladies and gentlemen, I have about 9 o'clock. I'm going to begin by calling the civil dockets. I'll ask for Forestville ISD versus Antonio Barrera.
Morning, Your Honor. Jeff Garcia on behalf of the tax entities in Wilson County. This should be a motion to vacate, Your Honor. We are simply asking the court to correct a legal description that was improper way back when we took the judgment. It referred to the town of Lodi, and we'd like to go back and correct that and add the city of Floresville, formerly known as the town of Lodi. We're ready on that if the court would entertain us.
Okay. Forestville ISD versus,
Judge, this is, we are ready on this one. This is the judgment, a default judgment.
Lavernia ISD versus Guadalupe and Maria Garcia.
We're respectfully asking to pass this case. We did not get confirmation of the notice of hearing letter that was sent to one of the defendants.
Okay. Reset on request. Wilson County versus Dora Gutierrez.
Your Honor, this case, Mr. Cedillos is an ad litem on the case. We're asking, this is a motion for excess proceeds. We're asking to get paid post-judgment tax here out of the proceeds that are in the registry of the court after a tax sale was conducted. And there is also a municipal lien that was filed by the city of Lavernia that we're asking to get recouped out of excess proceeds. So we're ready on that if the court will entertain us.
All right, and I think I saw Mr. Cedillos. There he is. Yes, sir. Are you ready on that case?
Mr. Cedillos, you're muted.
Yes. If you'd unmute.
Judge, I have no objection to going to them proceeding on getting that order signed.
Okay, thank you.
Thank you.
All right, Wilson County versus Chris De La Zerda.
Your Honor, we'd like to pass that and reset on request. It actually should be a non-suit. Taxpayers have paid in full. We just need to get confirmation.
Thank you. Wilson County versus Jonathan Taylor.
Plaintiffs announced ready for default judgment.
The matter of the marriage of Casey and Jose Leal.
Please mark as conferring, Your Honor.
Judge, I'm here. I'm sorry I'm not available to, I had some surgery yesterday on my head, and so I'm not fit for video, but if you'll mark as conferring, we'll see what we can accomplish.
I'll mark you conferring, and let me look at the screen here.
That's me.
No, I understand. I'm trying to see if there's anyone from the coordinator's office. Yes, Norma.
Yes, sir.
Okay, I'm going to make you the host.
Okay.
And you'll have to do the breakout rooms. If you will make me the co-host, I'd appreciate it.
Yes, sir.
Wilson County versus Juan Aldaba.
Plaintiffs announced ready, Your Honor.
Wilson County versus Araceli Holland in the United States of America.
Plaintiffs announced ready.
Wilson County versus Felipe and Nestora Guevara.
Ready.
Wilson County versus Javier Garcia.
Ready.
Wilson County versus Salvador Mendez.
Ready.
Wilson County versus Gilberto Perez.
Your Honor, we asked to pass and reset on request.
All right, Wilson County versus Melanie Williams.
Ready.
Wilson County versus A&M Electric.
Ready.
And Casey Shiraki.
Your Honor, we'd like to pass that. Ms. Tapia needs some more time to do some research. She's the ad litem on the case.
All right. 197547, in the interest of BEF, a child.
Your Honor, if you'll please mark as conferring on that.
Okay, and who was on the other side?
On BF, give me just a moment, Your Honor.
Your Honor, I'm the, this is Evelyn Huron. I'm the guest attorney appointed in this matter.
Okay,
I believe Mr. Ron Prince is on the other side.
And I think he's on, Your Honor.
I'm here, Your Honor. I'm sorry, I couldn't unmute. Could we confer, Mr. Pena, maybe in a breakout room?
Yes. Norma will be in charge of those this morning because she's going to host. Mark, you conferring. Wilson County versus Donna Holder.
I would like to pass on that. Mr. Ernst is the ad litem and he's requesting more time to do some more research.
Wilson County versus Raymond Sauceda
Plaintiff's announced ready.
versus Richard Esquivel
Ready?
versus ARC Pressure Data.
Ready?
Versus Tomasa Cazares.
Ready?
Lionel Guajardo,
Ready?
Carl Doppenschmidt.
Ready.
Matter of the marriage of Sharon and Eugenio Cortez.
Board President, Your Honor, if you'll please mark as conferring on that.
Correct, Your Honor.
Matter of the marriage of Donald and Megumi Sorrell.
Blake Pierce, Your Honor, on behalf of the petitioner Darren Sorrell, could I have Ms. Megumi Sorrell called via Zoom?
I'm not sure if the bailiffs are online, but I'll ask.
I can ask the bailiffs to call that name in the building here shortly, Judge.
Thank you. Wilson County versus Special Ops Service Company, LLC.
Plaintiffs are ready.
Wilson County versus Gary Ramsey.
And plaintiffs are ready, Your Honor.
Versus Shirley Whitford.
Same announcement. Plaintiffs are ready.
Matter of the marriage of Maribel Palacios and Justin Fish.
President, Your Honor, we're ready to confer with Mr. Fish. He's representing himself.
All right. And is he online here?
Yes, sir.
All right, let me rename you and I'll mark you conferring. Matter of the marriage of Elizabeth and Frederick Onosorge.
Herman Segovia here for the counter petitioner, Your Honor. We have an agreed order. We just need about 5 minutes to put on proof, and we've already submitted our decree.
Okay, I'll mark you number one.
Thank you.
Did you e-file the decree or how did you?
Yes, Your Honor. We e-filed the decree and the Rule 11.
Yes, sir. Both of those documents are currently in e-file. We just have not forwarded them yet to your queue. But I can do that.
Somebody would, on that, or just if you could just post it to me in chat, either one of you. The matter of the marriage of Denise and Donald Leonicio. I believe they're both here in the courthouse.
Yes, Mr. Leondicio is the Wils WC District Court Civil.
I'm here.
All right. How long to hear this? Is it agreed or divorce, unagreed divorce?
I'm here.
Okay, yes. My question is, do you have an agreement and a divorce decree already filled out? Do you have to?
Yes.
Okay. All right.
Yes.
RQA, I take up the uncontested cases where people are representing themselves after the uncontested cases with attorneys. So you'll be the first self-represented case I take up.
Okay.
Karnes County, TD Auto Finance LLC versus Fabian Contreras.
Matthew Clark, attorney for plaintiff. We're ready, Your Honor.
Okay, I think that's number 2.
Thank you, sir.
All right. Frio County case, GHT Enterprises versus Eduardo Rincon.
Carlton Spears here on behalf of the plaintiffs. Also, Trey Martin should be online. And Olga Brown on the other side.
Hi, Your
Right.
Honor. Good morning. I'm present.
Okay, and this is a motion to transfer and a motion to compel.
No, Your Honor, the hearing before this morning, we have an agreed order to come regarding the special exceptions on the pleadings. How, but I'm not quite sure what Mr. Martin would like to have heard this morning. Whatever it is, I would like to confer with him.
I think it was the matters regarding the discovery and the objections on the discovery. I don't know where Mr. Martin is.
I'm here, Carlton.
Okay, there you are.
Okay. Good morning, Your Honor. I had trouble getting unmuted there for a minute. There's three matters set before the court this morning: a special exceptions, motion to compel, and a motion to transfer venue. By agreement, the motion to transfer venue is going to be reset after the first of the year. The special exceptions we have reached an agreement on. An agreed order is being e-filed with the court. The motion to compel and overrule objections, we are going to need the court to hear that motion. And Your Honor, we'll speed it up as much as we can, but I'm thinking 15 to 30 minutes on that motion to compel.
Okay, I'll mark you 15 to 30 minutes, and I'll just make it 30 in case.
Okay.
There's no other people with numbers like that. And ask you to confer. Now, anyone else told to be here today on a case that was called, or was not called, on the civil cases? I see several folks who are here who have not heard anything from. Ms. Kennicott, Ms. Palacios?
Ms. Kennicott is my client, Your Honor. This is Ron Prince.
Okay, all right. Okay, now, I have unexpectedly wound up needing to do both the criminal dockets Judge Ellison was going to take and my own. So I have made Norma the host. She is in charge of breakout rooms. I have to go over and call the dockets on the criminal side, and that means I have to leave this meeting, go sign into Judge Ellison's meeting because he's unable to be there. So I will be back shortly. I'm going to be bouncing back and forth. But my plan is just to call the docket there. I know there are a number of pleas that are ready or close to ready, and then I will come back after I call the docket and do the everything that we can, the Frio County case, the tax cases, and the uncontested matters. So I shall be shortly.
Judge, do you need me?
Yes, no, no, Julie's over there.
Yeah, she is.
Yes, Julie's there for the for Judge Ellison's docket, so you just stay put.
Okay, thank you.
Miss Norma, are you on?
Hello? Sorry, missed that.
Oh, I was seeing, Renee, I talked to Jennifer. We're gonna just pass today since she has a criminal docket and we'll reset. We're
All
gonna enter, do you mind announcing that or informing the judge of that when he gets back?
Not a problem, Justin. We'll do that.
Thank you, sir. You have a good day.
You too. Take care.
Bye-bye.
Bye.
Stop, come here, hurry up. Go down. Go down, go down.
Yes, this is Ron Prince.
Hi, Renee. We're still conferring if that was the question. Mr. Finley, are you on? Mr. Finley? Ron, I'm gonna have to check and see where he's at.
Okay. Yeah, I still have you. You want to still stay on the phone, Renee, or?
Yeah, if that's okay.
No, I've got you. That's fine. Oh, that's fine.
Okay. Thank you.
Mr. Peña, this is Norma with the court coordinator's office. Did y'all need a breakout room?
We're pretty close to, I think, just passing on what my client needs to hear. I think we've made some headway. If we could just remain on the phone, because I haven't,
Okay.
my client's not on, and I need to figure out what's going on, where he's at. So.
Okay, yes,
If
sir.
you don't
Let me know.
mind. Okay, I will, Norma. Thank you. And I
Thank
know I
you.
have Mr. Fish. I see him on the other case with Maribel Palacios. And then, of course, Andy and I have a case as well, Cortez, and we're working through that. We're very close to getting that worked out. So let me call him as well and see where we're at, and then I'll report back to you. All right, Norma?
Thank you. Yes, sir.
Thank you.
Thank you.
No, get the fuck back. Go lay down. Oh.
All right, Norma, I've made you the host again. I found out that whenever I leave the meeting and come back, it automatically reclaims my hostship. So if you make me the host, I'd appreciate it.
Yes, sir.
All right, in the matter of the marriage of Onesorge, Mr. Segovia.
I'm here, Judge. Sorry.
All right.
Glitches.
Okay, and this is an agreed hearing?
Yes, Your Honor. Everybody signed off on the decree and everything. We just need to put on the proof. I don't know, my client, Mr. Ornithar, should still be on.
Yes, sir.
He's here. All right, Mr. Onesorge, would you raise your right hand? Do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. Go ahead, Mr. Segovia.
Thank you, Judge. Mr. Ornithar, before you filed your counter petition for divorce, were you a resident of Wilson County for 90 days in the state of Texas for 6 months?
Yes, sir.
You have filed your petition for divorce based on the fact that your marriage has become insupportable because of discord of personalities that destroys the legitimate ends of your marriage relationship. Is that correct?
Yes, sir.
And there's no hope of reconciliation. Is that correct?
Yes, sir.
You and your wife have, and she's represented by counsel Amy Owen. Is that correct?
Yes, sir.
And you and your wife have both signed and entered a Rule 11 agreement that deals with the conservatorship of your children and the division of property. Is that correct?
Yes, sir.
And you and your wife have both signed a divorce decree that incorporates that Rule 11 agreement as to the conservatorship of your children and the division of property. Is that correct?
Yes, sir.
Do you want the court, have you ever filed bankruptcy, Mr. Arnesarge?
No, sir.
Is your wife currently expecting any more children?
No, sir.
Okay. Do you want the court to grant and render your divorce on this day?
Yes, sir.
Okay. That's all I have, Your Honor. Thank you.
All right, and let me ask, was there any name change for the respondent?
They had not requested that, Judge. So I guess there is not.
Okay. Okay, and I'm sorry, did you ask about residence?
Yes, Your Honor, if he had been a resident of
Okay,
Wilson
fine.
County for 90 days and
Okay,
6 months, Texas.
okay, I find I have jurisdiction to hear this matter. The case has been on file for more than 60 days. The respondent has appeared here in court with his attorney and presented a divorce decree that's been signed off on by counsel and for both parties and by both parties. The petitioner had been a resident of Wilson County for 90 days in Texas for 6 months prior to the time this lawsuit was filed. The marriage between the parties has become undermined due to a discord or conflict of personalities, and there's no present likelihood of reconciliation. There were one child born during the marriage who has not reached 18 years of age, and I find that the proposed orders concerning that child are in the child's best interest and approve them. And I'll find that the proposed division of the marital property and debts is just, fair, and equitable, and I will approve it. And I will do the divorce in open court. Any relief that's not granted is denied, so this is a final appealable order. If you'll hold on just a moment, I will sign the decree and the Rule 11 agreement and post them online.
Thank you, Your Honor.
Or I'll just post them back to you and to the clerk. All right, and okay, and I don't see a signature block for me on the Rule 11, so I won't sign that.
Okay.
All right, give me just a moment. All right, it's not file stamped, but I've sent you a copy of the signed decree, Mr. Mr. Segovia. Good luck, Mr. Onosorge, and I've sent a copy to Ms. Kruger also.
Okay.
Thank you, Your Honor.
Maybe
You're ready.
excuse.
Yes, sir.
Thank you, Judge.
Good morning, Your Honor.
Good morning.
I'm sorry I was late for the docket. I have a case with Mr. Garcia from Lineberger.
Okay.
It's Laburnia versus Garcia.
All right. Yes, he'd asked to have that reset on request, but y'all are welcome to chat in a breakout room.
Yeah, that'd be great.
Okay. Give me just a moment. I've got one more thing, and then we're going to take the tax cases. It'll take about 5 minutes to do that.
Okay.
All right. Karnes County, TD Auto Finance versus Fabian Contreras.
Plaintiff present and ready.
All right, go ahead, sir.
Your Honor, this is a very simple debt claim case based on the theory of breach of contract. Our evidence will show that the defendant, Mr. Contreras, stopped making payments on 4/29 of 2016. However, we told the statute of limitations on October 18th of 2018 when we filed our petition. We subsequently perfected service on 11/3 of 2018. The answer was then due on 11/26 of 2018. And I would ask that the court take notice that we did file our motion for default judgment, and I would ask that that be entered into evidence at this time.
Okay, without objection, I'll take judicial notice of the district clerk's file.
Thank you, Your Honor. And in addition, when our petition was filed, we did have admissions. So at this time, with the the burden of proof being simple preponderance of the evidence and the defendant failing to appear and mount any sort of controverting evidence, and the fact that the admissions were deemed, I would ask the court direct verdict in the favor of the plaintiff for the amounts prayed for on our default judgment, sir. And that would be $29,882.19, pre-judgment interest of $1,928.20, and the post-judgment interest at 5% per annum to accrue. We will not seek attorney's fees. That's all I have, Your Honor. Plaintiff rests.
Okay, let me, I'm pulling up the return of citation.
Of course.
Okay, and do you have your military service affidavit?
That was, I believe that was in our default judgment on page, let me run this. And it's been 6 months. Would you like for us to rerun that, the SCRA and the affidavit for you and the declaration? Because I'm not showing
the return of service says he was 55 to 65 years of age. So
okay.
I don't think he's signed up since then. There's been times when, yeah, it's been a year old and they're 20 and I said, no, let's do this again.
Right. Thank you.
Okay, can you post whatever document you have to me in chat? I was on the Odyssey with the Karns district clerk and it just vanished. It kicked me completely out of Odyssey.
Are you referring to the default judgment packet that we sent?
Yes.
Okay. Give me 1 second, Your Honor. I'm going to mute myself and kill my camera while I do this.
Okay. All right, actually, I would ask you to post it to me in chat. If you go to chat and click on my name and then click on file, you can just send the entire file over.
Thank you, Your Honor.
I didn't know that until about August. All right, Mr. Clarkin, were you able to see the little dots next to my name on the far right-hand side on chat?
Yes, sir. I'm having to move it. I'm having to move it over. I selected you to chat. If you would just give me one more minute, 2 more minutes. I know you got a heavy docket. I'm sorry.
And while you work on that, I'm going to go ahead and call the tax cases. Mr. Garcia,
Thank you, sir.
ready on all the tax cases?
Yes, Your Honor, we're ready.
Okay, go ahead. I'll
Okay.
consolidate them on my own motion.
Your Honor, would you like, actually, I have one announcement prior to.
Oh, yes, sir.
And it's on page 5, the third case from the top, Richard Esquivel. It's 2002 130 CVW. Mr. Esquivel appeared there at the district clerk's office, and I instructed him to go to the tax office. We have since spoken, exchanged information, so we should be working out a payment agreement on that. So I want to pass that and perhaps reset it on request in the future.
Okay, excellent.
And then would you like to take the two cases, the motion to vacate and also the excess proceeds separately from the other default judgments, Your Honor?
Yes. Okay.
So at this time, if the court will allow, going back to the first page on cause number 1305, 313 Floresville ISD versus Antonio Barrera. That case is it's a motion to vacate. We are asking the court, we previously took a judgment on this case. The legal description through the title work reflected that it was located within the town of Lodi. We'd like to go back, vacate the judgment, and go back and correct the legal description so that if we have to sell it, which it appears we will have to sell it at some point, we can include language in the legal description that refers to the city of Floresville, formerly known as the town of Lodi. And so that is the reason for that motion to vacate, and we ask the court to approve that order.
I will approve that order.
Secondly, Your Honor, on the
sign the new one. Go ahead.
Thank you, Your Honor. Secondly, on the last case of the first page, 1709-565W, Wilson County versus Dora Gutierrez. That is a motion for excess proceeds. The section 34.04 of the tax code allows either the taxing entities or any lien holder to petition the court excess proceeds that were the result of a tax sale where property sold and there was excess proceeds that were generated from the sale. This property was sold back in February of 2020, and we are asking the court to, from the registry of court, get paid a post-judgment tax year of 2019, which will be reflective in Plaintiff's Exhibit B for the amount of $308.72 for post-judgment taxes, penalties, and interest. Secondly, we are asking the court to approve the payment of a City of Livonia municipal lien that was filed back many years ago prior to us taking a judgment, which has been marked as Plaintiff Exhibit A. That mowing lien is now in the amount of $3,089. Total, we are asking the court to approve a payment in the amount of $3,397.72 out of the excess proceeds. And Your Honor, based off of Plaintiff Exhibits A and B, we ask the court to approve of that order.
Okay. I don't have them in front of me, but I will pull the files. They're sitting over here next to me. So yes, pending that, I will approve that order.
Yes, Your Honor, we'll get those e-filed to you.
Okay.
And lastly, Your Honor, we make an oral motion to consolidate all the cases in which plaintiffs, the tax entities announced ready for default judgments.
Granted.
At this time, Your Honor, respectfully ask the court to take judicial notice of all documents and citations in the court's file, that all the necessary parties were properly served and have failed to answer or appear after being duly notified for today's court setting.
All right, I will take judicial notice of the entire contents of the clerk's files.
Lastly, Your Honor, we ask the court to enter into evidence which have been previously marked as Plaintiff's Exhibits A, certified tax statements from the Wilson County Tax Office showing the total amount of taxes, penalties, and interest owing and due to the plaintiffs, and we ask that those exhibits be admitted into evidence.
Without objection, plaintiff's exhibits are admitted into evidence.
And lastly, we pray that those judgments be entered in favor of plaintiffs based off of those exhibits. I'd like to inform the court, Your Honor, to page 4 and cause number 19-04-324, Wilson County versus Melanie Williams.
Yes, sir.
Ms. Williams did appear back in October of 2019, and she claimed that the mobile home was sold to 181 Homes. And I believe, Your Honor, you allowed the defendant, we passed the case, allowed the defendant to go ahead and try to implead 181 Homes because of the evidence that we still show as of yesterday that the mobile home is still registered to Ms. Williams under the state of Texas. So just wanted to inform the court on that one, that was the past history on that one. And as of yesterday, I checked the mobile home records and they're still under the taxpayer's name. So we'd like to proceed forward with that one.
All right. I will get on all this afternoon.
Okay, we'll get those e-filed to you, Judge. I appreciate it. And may I be excused?
Yes, sir.
Thank you.
Okay. All right, matter of the marriage of Rio Nicio. Do I have a copy of your proposed divorce decree?
Judge, it's in the file.
All right, give me just a second. Let me get that. All right, give me a moment to look this over. All right, Mr. Clark, you've shared your screen a couple of times, but I have not received anything from you in chat.
I'm not able to get the document to you alone inside of chat. I'm not seeing any options there. Would it be okay?
Let me just ask, when you go to chat, there's 3 little dots in a box to the far right-hand side, and you put your mouse on it and it says more.
I'm working mine off of an iPhone.
Oh, you're on an iPhone. Ah, okay.
Yes, sir. So I'm somewhat limited. Would it be okay? I don't want to hold up your dockets this morning. Can I email these directly to the court or e-file it? And would you grant it on submission so long as the
No, I'll do it on submission, and I'll just I'll just ask the clerk's office. Are they online? They were a while ago. Is Karn online? Yes, sir. If you'll just send that to the coordinator's office, I just need to see your military service affidavit and your proposed judgment, and I'll sign it. And like I said, I've never had that happen before, but it just went blip, and I was completely out of odyssey.
Well, I understand. See, I wasn't able to share that, and I apologize to everybody waiting in line. And Your Honor, thank you for having us, and I'll have that information to you by end of business today, sir.
All right, thank you.
If I may be excused.
You're excused.
Thank you, sir.
Mr. and Mrs. Leonosio, are you both ready to proceed? All right, ma'am, you need to unmute your microphone. And sir, you just muted yours.
There. Yes, I'm ready.
All right, and I just sent a message, ma'am, to ask you to unmute your microphone. Still muted.
Judge, one of the clerks is going to go help her since she is here at the building.
Okay, if you'll move the mouse around and put it on the little Hollywood square box that you're in, you should be able to mute and unmute yourself.
Excuse me, Your Honor. Ron
Yes.
Prince. May I make an announcement, sir?
Yes, sir.
On case 1907-0547 with Mr. Pena.
Yes, sir.
We have reached an agreement. I'm going to send him a Rule 11, and then Mr. Pena is going to do an order later.
All right, you're excused.
Thank you, sir.
Okay, let me ask both sides, are you both ready to proceed?
Yes.
All right, and Mr. Leoniso, you're muted again.
It won't, there. Can you hear me now?
Yes.
Yes, I'm ready.
All right, will each of you raise your right hands? You solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay. And
Mine won't unmute. Yes, sir.
okay, you're unmuted. Now just don't touch anything, and it should be fine.
It keeps going back. It keeps going back to mute.
All right. We'll just have to watch that. Okay, let's see. Ma'am, you are the petitioner, so I'll ask you, prior to the time this lawsuit was filed in September.
Right. Yes, sir.
Had you been a resident of Wilson County for 90 days?
For
Okay,
35 years.
Ma'am,
Yes.
ma'am, let me finish my question. Prior to the time this lawsuit was filed back in September, had you been a resident of Wilson County for 90 days and Texas for 6 months?
Yes.
You're married to Donald Lawrence Leonicio.
Yes.
Has the marriage between the two of you become undermined due to a discord or conflict of personalities, meaning you're just not getting along?
Right. Yes.
When were you married?
April the 10th, 2010.
Okay. And have there been any children born to you since that time?
No.
Adopted?
No.
And are you expecting a child?
No,
And have either of you filed bankruptcy during the marriage?
no,
Okay. Now, I need to tell both of you that the law in Texas presumes that every single thing a married person owns is community property, meaning that you own it together. The moment you get married, the law presumes it's all community property, even though
yes,
okay, let me finish. Even though everything that you owned previously is your separate property. If the divorce decree that I signed does not divide some item of property and say it's community property and here's how it's being split up, or it doesn't say this property that is not community property because, for instance, you owned it before the marriage or you inherited it. If neither of those things happens, then the law presumes that the two of you still own it together, even though you're married or divorced. And many years from now, creditors from the ex-spouse can come back and try and get a hold of some of the property and claim that they're entitled to get half of it. So it's not just a matter of what y'all are disputing or whose name is on property. Anything that you have that's valuable enough, there might be a lawsuit filed over it one day. We need to spell out in the divorce decree either who it's being divided up to or that it doesn't need to be divided up because it's separate property. So I saw that you listed a lot of some pieces of property in here. Is there any property that you listed that you failed to list that needs to be on here?
no,
Okay. And do you think that it's the way you and your husband have proposed to divide your debts and your property is a fair thing to do?
well, there's only there's only two things that I have to say. The car was a gift to me
Okay,
from
ma'am.
my husband.
All
And
right.
now,
Ma'am, that's a yes or no question. Is this a fair way to divide up your property?
no,
Okay. Why isn't it fair?
because the car was a gift to me from my husband on my birthday, and now he's saying he doesn't want to make the car payment. And then the house, he said, I'm going to make payments on the house until the divorce is final, which is today. And he didn't make the payment November the 1st, which he should have made.
Okay.
So those are the two problems I have with him. That's it.
Okay. And was the house purchased during the marriage?
No, the house was given to me by my deceased husband. When he passed away in 2007, the house was willed to me.
All right. So the house is your separate property.
Yes,
Okay. All right. And you're asking to have a previous name restored?
a previous name, like change the name to my name, or what do you mean?
Your divorce decree says that you want to have your name changed from
Oh,
Leonis.
yes. I want to have my name changed to Denise Stacy Villanueva.
All right. And that's a previous name of yours?
Yes.
All right. Mr. Leonisio, do you have any for your spouse at this time? Okay. You're muted. Still muted. You're still muted, sir. Okay. Do you have any questions for your spouse at this time? You're in.
Judge, we've got, a clerk is going to go help him with the computer.
I'm gonna stay in here for just a little bit.
Okay, but it says mute now.
No, he can hear.
Sir,
you.
it says mute because it's giving you the option of muting yourself.
Okay, so can you hear me now?
Yes, that's why I'd said just don't touch anything and you're fine.
Okay, thank you.
All right. Do you have any questions for your wife at this time?
Well, she moved a man into the house the day after I
No,
left.
no, sir, no, sir, no, sir. I'm not asking for testimony.
Okay,
And do you have any questions for your wife this time?
no questions.
All right, you heard what she testified to. Is that true and correct?
No, sir. I did not say I'd pay for the house. Once I left the house, I told her she'd pay for the house. I did pay for the car and
Okay.
paid $500 towards the house.
All right, sir. And can you think of any property that the two of you have, or either of you have, that needs to be spelled out in the divorce decree with more clarity, who is going to wind up with it?
No, sir. I'm giving everything to her in the house and all the property with the house.
Okay. Now, I saw that there are storage sheds and things that you're receiving.
Yes, sir. I already took them.
Okay, all right. So this is not a situation where you're going to have to be going back over there for 6 months to get stuff out of storage sheds.
No, sir, not at all. The only other thing I have is I have bills that we took out together for paying off credit cards, totaling about $30,000 with payments of $1,200 a month. And half those bills should be hers, but I agreed to keep them too.
All right, sir.
Right now.
All right. Anything else?
That's all.
Okay, I'll find I have jurisdiction to hear this matter. The case has been on file for more than 60 days. The respondent had both filed a waiver of citation in the proper format and appeared in open court and announced ready. The petitioner had been a resident of Wilson County for 90 days in Texas for 6 months prior to the time the lawsuit was filed. The marriage between the parties has become undermined due to a discord or conflict of personalities, and there's no present likelihood of reconciliation. There were no children born or adopted during the marriage, and none are expected. And I will find that the proposed division of the marital property and debts is just, fair, and equitable. I will restore the petitioner's previous name of Villanueva, and I will grant the divorce in open court. Any relief not in the divorce decree is denied. So this is a final appealable order. I wish all good luck. I've signed this. You've got your Bureau Vital Statistics sheet, so you'll be able later this week to get certified copies of the file stamp decree from the court, the clerk of the court. All right, and I'm going to ask for announcements real quick, and then we'll go back and work on the Frio County case.
Are we finished?
Yes, sir.
Well, thank you very much.
All right, in the matter of the marriage of Liao, what's going on?
Your Honor, I spoke with the opposing counsel. I thought I was on the criminal docket. I thought he was going to announce that we were just going to reset that. It's just a docket control order. We're just going to have to get a trial date, and then it'll be agreed, and then just submit that for the court signature.
Okay, well, he's left, so I guess he was happy with that.
So do we have any, do we know what, I'll just get with the clerk, Your Honor, with regard to trial dates.
Please.
And Your Honor, in the matter of the marriage of
No, hold on, I'm going down the list. Okay, you are next. The matter of the marriage of Cortez.
We're going to drop the setting, Your Honor, and then reset upon request.
All right.
That's
thank
correct,
you.
Your Honor.
Okay, the matter of the marriage of Sorrel.
Good morning, Your Honor. I had Miss Megumi Sorrell called. I don't believe there was an answer, so we have a default 15-minute, 20-minute default.
Okay, I'll take that next. Or actually, there may. I'll take that next. The matter of the marriage of Palacios.
We have an agreement, Your Honor, proof. No more than 10 minutes.
All right, I'll take that. afterwards. It's number 4, I think. That's it. All right, the matter of the marriage of, sorry. My computer, I have more trouble with this darn thing. Sorrel?
Yes, Your Honor.
All right. Is your client present?
Yes, Your Honor. His name is Daryl Sorrell. I believe he's connecting to audio.
And Judge, I did ask the bailiffs to call Megumi Sorrell, and there was no answer.
Okay. Has your client connected to the audio previously, or has it been saying connecting to audio since he signed on?
Since he signed on, Your Honor.
Yeah, that's not gonna, if it hadn't happened by now.
Yeah, Mr.
To exit and then try to rejoin. And while that's going on, I'll take Mr. Pena's case, the matter of the marriage of Palacios and Fish.
We're ready, Your Honor.
All right. Mr. Fish?
Yes, sir.
Okay. All right, let me ask that you're ready to proceed?
Yes, sir.
Okay. Would you remove your hat?
I'm sorry, sir.
All right, would each of the parties, Maribel Palacios and Justin Fish, raise your right hands. All right. Each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
sir.
Go ahead, Mr. Pena.
Thank you, Judge. Ms. Palacios, are you the petitioner in this cause?
Yes.
Is Mr. Fish the respondent in this cause?
Yes.
Have you lived in the state of Texas for at least 6 months in the county of Wilson for at least 90 days?
Yes.
Were you married on or about June the 26th, 2019, and separated on or about June the 10th, 2020?
Yes.
Your Honor, we'd request a trial amendment in terms of the date of marriage.
Okay, go ahead.
All right. Are the children of the marriage?
Yes.
Would you state their names, please?
Eliana Rose Fish and Samuel Isaac Fish.
Are you asking this court to appoint you as joint managing conservators of the children, with you having the primary and exclusive right to establish the home for the children?
Yes.
Has the marriage basically defaulted because of insupportability and discord or conflict of personalities between you and Mr. Fish that destroys the legitimate ends of the marriage relationship and prevents any reasonable expectation of reconciliation?
Yes.
With regard to the, if you'll bear with me for just a moment, to the visitation, your visitation will be as you mutually can agree. Failing the mutual agreement, that it would be the standard possession order. Is that
Yes.
correct? However, the children are under the age of 3. Is that true?
Yes.
And until they reach that particular age, the visitation will begin on every other Saturday, the first, third, and fifth Saturday at 8 a.m. and end at 6 p.m. that same Saturday. Is that correct?
Yes.
The pickup and drop off will be at your home. Is that correct?
Yes.
After that period in time, then Mr. Fish will have the right to have the standard possession order. Is that true?
Yes.
Have you reached an agreement regarding child support?
Yes.
Are you asking this court to award you $590 per month beginning on November the 1st of 2020?
Yes.
And that is giving credit to Mr. Fish for the $100 that he would be paying for the government insurance program for the insurance of these children. Is that correct?
Yes.
All right. Regarding the division of the property, are you asking this court to award you and Mr. Fish any property that you have sole control and possession of as of the date of the separation? Is that correct?
Yes.
Okay. With regarding the debts, you're asking that Mr. Fish be awarded the debt on the 2010 Dodge Avenger. Is that correct?
Yes.
Any debts that were incurred after June 10th, 2020 by you or Mr. Fish, is that correct?
Yes.
As well, that you be awarded a debt to Conley Memorial Hospital. Is that also correct?
Yes.
Okay. And I'm not sure I asked you this question, but Mr. Fish should be awarded the 2010 Dodge Avenger.
Yes.
Okay. And you're not asking for a name change?
No.
Okay. And you're asking this court for a divorce here today?
Yes.
Your Honor, I pass the witness.
Mr. Fish, this is not a time for you to testify. It is a time for you to ask questions of your wife. Do you have any questions for her right now?
I'm sorry, sir. No, I don't.
All right. Does a movement rest, petitioner rest?
Well, Your Honor, I'd like to just ask Mr. Fish a couple of questions, if I may.
Sorry, go ahead.
Mr. Fish? Mr. Fish?
Yes, sir.
All right. You've heard me basically ask the questions with regard to the custody, visitation, the grounds of divorce, the child support, and the division of the debt and assets. Is that correct?
Yes, sir.
Are you in agreement with what your wife testified to?
Yes, sir.
All right. I have no further questions, Your Honor.
All right. And did you have any questions for your wife at this time, Mr. Fish?
No, sir.
All right. Anything else from either side?
No, sir.
Okay. Do we need an entry date?
Yes, sir. You can give us one.
All right. How long do you need to get this drawn up, Mr. Pena?
I've already drafted it, Your Honor. I just need to make a few changes to it. 2 weeks is fine.
Okay. All right. Well, I'm going to be doing dockets and civil dockets. Let's set this for December 1st. That's probably Judge Ellison's docket. That's Judge Ellison's docket, but we can move it over to mine. All right, Mr. Fish, what's going to happen is Mr. Pena will draw up a divorce decree to reduce all of this to writing. That's the document the judge has to actually physically sign or electronically sign to make the divorce final. As long as you are content that the document Mr. Pena produces is what you've agreed to, if you will just sign it, Mr. Pena will sign it and he'll file it with the court electronically, and nobody needs to be here on December the. If, on the other hand, you have a disagreement with Mr. Pena about whether or not the document he's produced is what you agreed to, and you're not able to get that worked out, then I'm making this for December 1st for an entry, and we'll have a hearing at that time to make sure that we get the final order signed. All right.
Yes, sir.
We all have, you are excused.
All right.
Okay. Mr. Pierce?
Yes, Your Honor.
Okay. All right. Your client has signed on and he's muted. So let me ask him to unmute. Thank you. Mr. Searle, will you raise your right hand? Do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. Go ahead, Mr. Pierce.
Thank you, Your Honor. Would you please state?
Let me interrupt you and say I'll take judicial notice of the contents of the file, including that there is a return of service in the proper format that's been on file that shows that the respondent was served in Monterey County, California some time back, and that there's been no response filed and her answer date is passed.
Thank you, Your Honor. Would you please state your name?
Daryl Sorrell?
Are you presently married to Megumi Sorrell?
Yes.
Have you been a domiciliary of Texas for the preceding 6-month period and a resident of Wilson County for the preceding 90 days?
Yes.
Were you married to Ms. Sorrell on September 28, 1984, and did you cease to live together as spouses on or about February 1st, 1992?
Yes.
Has your marriage become insupportable because of a discord or conflict of personalities that destroys the legitimate ends of the marriage relationship?
Yes.
Is there any reasonable expectation of reconciliation?
No.
Were any children born during the marriage?
Yes.
And how old are they now?
30 and 35.
Were any children adopted?
No.
Is your wife expecting a child at this time?
Not that I know of.
Do you think that the agreement is a just and right division of the community estate?
Yes.
Are you asking the court to award you all your household goods and equipment in your possession or subject to your control?
Yes.
Are you asking the court to award you all clothing, jewelry, and other personal effects in your possession?
Yes.
Are you asking the court to award you all sums of cash in your possession?
Yes.
Are you asking the court to award you any and all retirement accounts in your name?
Yes.
Are you asking the court to award you all the sums, the proceeds therefrom, and any other rights related to or as a result of your service in the U.S. Army?
Yes.
Are you asking the court to award you all policies of life insurance in your name?
Yes.
Are you asking the court to award you the 2002 BMW?
Yes.
And Mr. Pierce, if it's as long, just, he wants everything in his possession?
Yes, sir.
Okay, all right.
Okay.
What else?
And you're fine with Ms. Sorrell having everything in her possession, Mr. Sorrell?
Yes.
Is your wife requesting a name change?
Not that I know of. Haven't heard from her.
Okay. Are you involved in bankruptcy?
No.
And does your signature appear on the proposed final decree of divorce?
Did I sign it yesterday? Yes, I guess. I'm not sure.
Are you asking the court to grant you a divorce today and approve the proposed final decree of divorce?
Yes.
That's all I have, Your Honor.
Right. Mr. Sorrell, have you been providing any support to your spouse?
No, sir.
Okay, and that's fine. I just wanted to make sure it was. All right, then I'll find out jurisdiction to hear this matter. Like I said, the return of citation has been on file for some months. There's no answer on file. There is a certificate of last known address and a military service affidavit in the proper format. I'll find that the petitioner was a resident of Wilson County for 90 days in Texas for 6 months before the divorce was filed. Mr. Sorrell, are either of your children handicapped to where they're unable to support themselves?
No, sir.
There were no children born or adopted during the marriage. You haven't reached 18 years of age expected. And I find the proposed division of the marital property and debts is just, fair, and equitable, and I will approve it. Pronounce the divorce in open court. And Mr. Pierce, do you have your proposed divorce decree?
I have it on file, Your Honor. I think I filed it yesterday.
All right.
It is an e-file. I'm sorry, Judge. I can go ahead and put that into chat for you.
Okay. Yeah, they're shorthanded at the clerk's office today. I have not received anything today from new in my judge's queue. So if you could send that to me in chat, I'd appreciate it. I'll go ahead and sign it.
Sure.
Yes,
Okay. Any other announcements before we start the Frio case?
May we be excused, Your Honor?
Yes.
Thank you so much.
Your Honor,
Yes, sir.
in the interest of VEF, I believe we're going to putting together a Rule 11 agreement, and we'll report back to the court, let you know if all parties have signed it. So at this point in time, we don't expect a hearing.
Okay, excellent. All right. GHK Enterprises versus Rincon.
Yes, Your Honor. Trey Martin here on behalf of GHK and the movement. Your
All
Honor.
right, and can, let me ask, can someone post to me whatever pleadings I need to look at, post those in chat?
Okay. We'll, I'll get some help and get that done right away, Your Honor. Your Honor, I think the announcement is less now than I previously indicated to the court. We did confer and we were able to agree to a good portion of the motion to compel relating to interrogatories and requests for production. We were able to reach an agreement with the special exceptions. We e-filed an agreed order with the court and we request the court to sign that. It's been signed off on by both plaintiff and defense counsel. So I think the motion to compel is probably more in the neighborhood of 15 minutes, but we'll certainly get this to your chat box immediately, Your Honor.
All right, thank you, and give me a moment to grab a legal pad.
Okay. All right.
Hello? Oh, okay. I didn't know what was going on.
All right, I'm back.
Okay, Your Honor, we're trying to pull that up real quick and get it to you.
This is Dahlia from the district clerk in Frio County. I just posted in the chat the agreed order. That way it's ready for y'all.
Thank you.
Thank you. Your Honor, while we're getting that to you, would the court allow me to give you a little bit of background on this matter?
Yes, sir.
Your Honor, I want to give you a brief bit of background factually so the court understands the need for the request for admissions that the plaintiff has sent. There's 91 of them that are in issue, and I'd like to walk the court through why it's necessary and the idea behind streamlining the authenticity of the documents, signatures, etc. Your Honor, GHK Enterprises is a company that buys and sells land. GHK is owned by Senator Glenn Cothman. Your Honor may recall who Senator Cothman is. After graduating from Texas A&M, he went on and became a five-star or a general. I'm not saying five-star, but a general in the Army Reserve, and then he was a state representative and a state senator for many years.
Yes, sir, I'm aware of it.
Okay. Mr. Cothman, Senator Cothman, through his business entities, has provided financing and land ownership opportunities to folks that cannot typically qualify for traditional financing or the ability to afford housing. GHK subdividing owns and subdivided a tract of land in Frio County, and it sold lots out of that. All these tracts were encumbered by restrictive covenants for the good of the subdivisions. Mr. Rincon, the defendant in this case, purchased lot 85 out of the Patton Ranch subdivision. In doing so, Mr. Rincon signed a number of transactional documents, including a executory contract, promissory note, deed of trust, and was issued a warranty deed in accordance with the executory contract. From 2014 through February of this year, Mr. Rincon was in a constant state of default. He was regularly behind in his payments and violated the restrictive covenants, both of which are events of default under the deed of trust. From May 14th until August of 2019, Mr. Rincon was foreclosed upon 6 separate times, and GHK, although had no obligation to do so, allowed him to catch up and cure his defaults, and they reinstated the loan and the lien document 6 different times. The last and final foreclosure took place in February of this year. GHK now owns lot 85 pursuant to the non-judicial foreclosure and trustees deed. Mr. Rincon continues to occupy, at least through his property, Lot 85, and continues to assert wrongdoings on behalf of GHK. As such, GHK filed this lawsuit with this court in July of this year, seeking a declaratory judgment that the loan documents are valid, that a default existed, that GHK properly exercised its rights under the loan documents and applicable law to foreclose on Lot 85. We had special exceptions, Your Honor. As mentioned, we reached an agreement on those. And then on the motion to compel, we have reached agreements on interrogatories and requests for production. And I wanted to go through that background because over the years, a number of documents were signed and agreed to between GHK and Mr. Rincon. And Your Honor, we're down to the request for admissions, and these admissions, Mr. Rincon has objected, saying that they're demand admissions. In other words, admit you're liable to the plaintiff or admit that you're negligent. These admissions are far from that, and they're exactly geared to what admissions are supposed to do. For instance, requests for admission number one, or number two, admit that you signed the original of Exhibit 1. Number one, admit that Exhibit 1 is a true and correct copy of the original. Admit that Exhibit 1 states certain language on Exhibit 1. This repeats itself with the various different documents, including the reinstatement documents and loan documents that are at issue in this lawsuit. Mr. Rincon has objected, saying that they're demand admissions, which are not. He also objects, saying no contract exists between the parties, even though he signed numerous agreements, ratified and waived any conduct through reinstatement documents. Mr. Rincon also, in his objection, states that all facts are disputed, for whatever that means. Your Honor, with these requests for admissions, the law is very clear that you have to either admit or deny or set forth with very particularity in accordance with the rule. Lack of knowledge is not a proper response unless the responding party states that a reasonable inquiry was made, but the information known to him or easily obtainable is insufficient to enable the responding party to admit or deny. These are all documents Mr. Rincon signed. These are all documents that he has in his possession or had in his possession. And when resorting on whether he has information sufficiently available, he's got to take advantage of any source available to him, including his attorney. Certainly, Mr. Rincon knows whether that's his signature or not on these documents. Certainly, Mr. Rincon knows if these are the documents that he signed. Certainly, Mr. Rincon, through his attorney, can answer admissions as to what the document states in a certain paragraph. And we're trying to streamline the facts of this case. And so we can present through a motion for summary judgment and move this case forward, as economically and considering the judicial resources of this court. And so we're asking, Your Honor, that Mr. Rincon's objections, 1 through 91, they're all very similar. They all deal with a document, a transactional document. Overrule those objections and require him to answer in accordance with the rules of procedure. And right now, there's nothing but evasive answers. He says he cannot admit or deny because he allegedly only speaks Spanish. Well, he spoke quite a bit of English when he was dealing with GHK, but nonetheless, just because you speak Spanish doesn't give you a right to breach a contract. It doesn't give you a free pass on answering discovery and complying with the rules, which that seems to be the position in this case. So, Your Honor, we would request that the court overrule his objections and require responses in accordance with the rules of procedure, which they're not done at this point in time.
Okay, and if you could give me a copy of your motion, I'd appreciate it. I have the receipt.
I'm gonna get a little help here, Your Honor.
All right, Ms. Brown.
Thank you, Your Honor, and good morning. If the facts before Your Honor were as such that as Mr. Martin is presenting or representing this morning, I wouldn't be here. Mr. Rincon would not be here. Mr. Rincon is a laborer. Basically, what he does is he works with concrete, and he barely speaks English like yes or no, but he does not write English, and he definitely did not have the opportunity to have this matter translated in English. Now, the requests for admissions are not to streamline the issues in this case. They are basically against the rule. I have prepared just a very brief trial brief, bringing to the court's attention 2 cases. And we heard Mr. Martin admit, we want these answers so that we can come before the court and ask for a summary judgment.
Isn't that the purpose of admissions?
Admissions, yeah. He wants to compel an admission to the request for admissions so that he can come and get a summary judgment. So, Your Honor, really what this amounts to is that this motion or this motion to compel answers today is a backdoor way of getting rid of this case. I represent to you, Your Honor, that every request, all 93 of them, is regarding a material fact that is controverted in this area. Basically, this is what happened, Your Honor. Mr. Rincon was very interested. He had a dream of owning rural country property. He was already in ownership of a nice home in San Antonio on Crestview, in reliance that JHK, Mr. Kothman, would transfer title to the lot to him. He sold this property. He sold his home. He is basically now homeless. While Mr. Martin would like to bring up all of these qualifications of Mr. Kothman, and I very reluctantly bring this up, but I want the court to know that Mr. Kothman and his assistant, Andrea Thompson, are under investigation for failure to have a license to finance this home mortgages. If you do more than 4, according to the state, you must be licensed. They have not done that. They've issued, that I know of, because of what's on record in Frio County, more than 30. You know, it would be like this, Your Honor, not having a driver's license and causing 30 wrecks. This is very important, I think. And another very material fact I would like to point out to Your Honor is this. Mr. Rincon has never met Mr. Kothman. The loan originator, the deed of the trustee under the deed, the notary, every aspect of this transaction, of this contract, was done by Ms. Andrea Thompson. Originally, I wanted to take her deposition under Rule 202 so that I could bring before the court only true facts concerning this matter. It was denied. Basically, the court said, just go ahead and file your lawsuit. Yesterday, Your Honor, I very reluctantly filed a counterclaim that included Mr. Kothman individually, Miss Thompson, and Mr. Mucha. Sorry about the pronunciation. So I have given Mr. Martin, by my counter claims, complete and fair notice of why we are before the court.
Okay, and I think I've got enough background from both sides, but I don't have a copy of the motion to compel, so I have no idea.
Your Honor, we're trying to do that. Can you remind me again how this is done? I've got.
Okay, if you'll click on chat and then my name.
Okay.
And then move your mouse over to the right of my name, and there should be a box with 3 dots in it. You put your cursor over it and it says more.
Okay, we're working.
Okay, I've got to the thing that says more.
Okay, click on that, and is file one of the options?
No, unfortunately, the only options, Your Honor, are away, take a break, clapping hand symbol, and up and down. Unfortunately, there's no file that I can see.
Okay, and that's a chat?
That is in chat, yes.
Okay.
Of course, it's on file. We can, is there any way that the Frio County clerk could send it to you, Your Honor?
Your Honor, we would be happy to send it to Your Honor.
And that's fine, as long as I get it from someone. Okay.
Mona will send, Ms. Flores, Mona Flores is my assistant, and she'll be sending it to you, Your Honor. And Your Honor.
And I don't think that, but I don't think you're clicking on the right place, because that's not what should come up. There's another more that comes up, but if you click on the chat and go to the very bottom right-hand corner of the box that pops up on the side of the screen. Now, Zoom is funky sometimes. I know sometimes it will allow one person to do something and not allow the other person.
We're trying, Your Honor.
What I have 2 Trey Martin and then privately, and then I move the cursor over and it says more. Now, Ms. Flores has sent me the motion to compel.
And when I go to those 3 dots over to the side, it just asks, when I press more, it says save chat. That's my only option.
Okay. Zoom is funky. All right. So what's the first? Okay, what is the first request for admission that we need to look at? And what page of the motion to compel is that on?
So, Your Honor, we start discussion of the request for admissions on page 19 of the motion to compel. And the first one is admit that the document attached here to is Exhibit 1 entitled Contract and Agreement is a true and correct copy of the original such document.
Your Honor.
Okay, hold on. I'm trying to find that on
That's on page 20, Your Honor, the motion to compel.
page 20. Okay, I thought you said 19.
Page 19, the discussion about the objections lodged, but page 20 is the first admission.
All right, Ms. Brown.
Thank you, Your Honor. I didn't mean to interrupt, but I think that Mr. Martin is reading from requests that we supplemented yesterday. We've already supplemented some of the requests for production, the requests for admissions that we felt like under the rules, we had to give a specific reason why we couldn't admit or deny, and we have done that, Your Honor. We have done that. So he will have to go to the answers that we filed with the court yesterday. And I think this will save us some time too.
Well, Your Honor, we did receive this. It was in response to our motion that was set for hearing today. So yesterday they supplemented, but the same objections to each admission are still there. And this is the response to number one. Can neither admit or deny, and that Rincon does not read or write English and would have no way of determining that the document attached as Exhibit 1 was the true and correct of what was presented to him in English only on the date of the document. Your Honor, he signed these documents. If this is the same document that he believes he signed, then it's true and correct. If he didn't alter it, it should be true and correct. Admission number 2, admit that you signed the original Exhibit 1. Same response. And then he goes on, Rincon admits the signature on Exhibit 1 may be his. He won't even admit that that's his own signature. So we just need these cleaned up so we can streamline the issues, get these documents proven up, and move forward with this case.
If I may, Your Honor.
Yes.
The reason that we put may be his signature, because some of the documents that were provided to Mr. Rincon have different varieties of his name. The signatures vary across the docs. When Mr. Rincon came to see me, he brought me 2 pieces of paper that he had been given. At that very time, I said, are these copies of the originals? He did not know, Your Honor. We have provided the 2 sets of documents that were given to us. Additionally, Your Honor, we also, before suit was filed, wrote to the plaintiff, GHK, and said, please provide me with a copy of Mr. Rincon's record. Because, Your Honor, I didn't want to barge into this lawsuit if there was nothing there. Mrs. Thompson provided me with an incomplete record of Mr. Rincon's account. In response to the request for production, I have provided that. So again, I urge the court to consider that the only reason they want this is to exclude this case. And that is not the proper use of the request for admissions. I represent to the court as an officer of the court that each request here that we have not clearly admitted or denied is questionable at best and is definitely controverted. I would like to give the court one example. They used the violations of restricted covenants to withhold payments. Not receive payments from Mr. Rincon. When they refused to accept payments, then they went ahead and foreclosed. Now, Mrs. Thompson is the whole judge of whether or not there's been a violation. Now, I told Mr. Martin, I can go through each one of the violations that have been perpetrated on Mr. Rincon. For example, Chapter 5 of the Property Code requires that JHK provide Mr. Rincon with a copy of the deed restrictions that they used as a reason to foreclose. Before or at the time that they entered into this executory contract, they did not. They were not given to him until after Mr. Rincon had paid $3,500 and had signed off on the paper. So
let me ask, how many of the requests for admissions did you supplement your answer to?
I supplemented all of them, Your Honor, that I could not admit or deny. I would like.
How many is that?
All of them, Your Honor.
There's 91 at issue in this motion, and although she supplemented them, the supplementation doesn't cure the problem, Your Honor.
Okay, all right. And I don't have, do I have the copy of the supplement? Here's what I'm going to ask someone to do. I'm going to recess the hearing and ask someone to take an Excel spreadsheet and just have 3 boxes wide. You can make it landscape so it fits on one sheet of paper, and have request for admission, answer, supplemental answer. So what I can see for each and every one, what the response is, because I already have a copy with the motion to compel. Do I have copies of like where it says number 56, admit you signed the original exhibit 10 attached here too. Do I have a copy of that exhibit 10?
We'll make sure you do, Your Honor. We'll take lead on that spreadsheet. We'll copy Ms. Brown on it, and we'll submit it to the court. We'll make sure all the exhibits are there for the court to review.
Your Honor, I believe that your request is so reasonable, because anytime a movement wants this, we'll have that spreadsheet, and then all the court has to do is rule on it. So I appreciate Your Honor asking Mr. Martin to do that.
Well, again, I have no preference as to who does it, but that way as long as it's not me.
We're happy to do it, Your Honor, and obviously we don't agree with what Ms. Brown just said about GHK, and we don't agree that Chapter 5 even applies to this transaction. We can show the court exactly where it doesn't, but that's for another day. That's for a motion for summary judgment. We're just trying to get the documents and signatures proven up.
Okay, all right, and I'll make a note here that reset on request. If I think I need to set this for argument, I'll do it. If not, I'll rule on submission, but let me look at that first. Okay.
And Your Honor, the other agreed order should be before the court.
All right, I already signed one and posted it back.
Okay. And then we're going to handle the rest of the interrogatories and requests for reduction by Rule 11, and I'll get that to Ms. Brown.
Thank you, Mr.
Martin.
Okay, excellent. All right, anything else on the civil cases right now? Okay, I'm going to leave this meeting running. Norma is still the host, so I'm going to leave it. Norma, let's leave the meeting up, and I will go back over to the criminal side, but I believe we're finished. Lachey, if you want to take off, I'll call you if we need anything, but I don't, actually, we shouldn't need you back. I'll just, Julie's.
Your Honor, can we be excused on the Frio County case?
Absolutely.
Okay, thank you, Your Honor.
Your Honor, thank you so much.
Thank you, Judge.
Thank you.
Good day.
Thank you, Your Honor.
Judge, I'll see you Monday. he already got off Lachey. He's in Judge Ellison's court.
Okay. So
Hey,
Monday it
Norma.
is.
Yes, ma'am.
Okay. Y'all have a good
Thank
weekend.
you. You
Norma.
too. Yes, ma'am.
On our civil docket, do you know what the announcement was on Cortez? It's on the bottom of page 6.
Page 6.
Because I see everyone is pretty much gone.
Yes, ma'am. That one was dropped, reset upon request.
Oh, okay.
Yeah.
All right. Thank you.
If you want to forward me your notes
Sure.
when you have a chance, please.
Yes, I will.
Thank you. I appreciate y'all's time.
You're welcome. Thank you.
Thank you. Judge, you're muted.
Okay, I'm back. Is there anything that we all finished up over here?
Yes, sir. I guess Mr. Pena never came back with a Rule 11 or anything. He said he had entered an agreed order, but nothing else. Everybody's gone.
All right, he probably e-filed it or something.
Yes, sir. They didn't come back.
Go ahead and end this meeting, and I'll get my chat and everything over to the coordinator's office shortly.
Okay, very good. Thank you, Judge. Appreciate it.